While birthright citizenship has been a very hot topic over the last several years, one question seems to have boiled to the top. The question presented is whether the Constitution guarantees citizenship to children born in the United States of parents who are unlawfully or temporarily present in the country. The question revolves around the language of the first section of the 14th Amendment, which reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." Specifically, what do the words "and subject to the jurisdiction thereof" mean? On January 20th, 2025, President Trump issued Executive Order number 14160 titled Protecting the Meaning and Value of American Citizenship. The order provides that children born in the United States of parents who are unlawfully or temporarily present here are not subject to the jurisdiction of the United States and thus do not qualify for citizenship under the 14th Amendment or the Immigration and Nationality Act, which uses the same language. What seems lost in most of the debate around this executive order is the fact that it mirrors the language of federal law, which mirrors the language of the 14th Amendment, specifically, and subject to the jurisdiction thereof. Yet, that did not stop people from filing suit. Several plaintiffs filed suit, some in the name of their children, arguing that the executive order violates the 14th Amendment and the INA. The district court agreed, provisionally certifying a nationwide class of children who would be denied citizenship by the order and preliminary enjoined the order's enforcement. This court granted certiorari before judgment. Okay, problem number one. How can an executive order that uses the same language as the Immigration and Nationality Act and the 14th Amendment violate both of them? The Citizenship Clause must be understood in light of its historical context, from the English common law to the widespread condemnation of the court's decision in Dred Scott v. Sanford. Does anyone else find it ironic that Chief Justice Roberts is using English common law to justify a decision about the American Constitution on the 250th anniversary of the publication of the Declaration of Independence? I thought we declared independence from, among other things, rule by judges. After all, that is what English common law is. The ancient law of England based on societal customs and recognized and enforced by the judgments and decrees of the courts. The general body of statutes and case law that governed England and the American colonies prior to the American Revolution. This common law citizenship, known as jus soli, or right of the soil, crossed the Atlantic and prevailed in each and all of the states after American independence. Now, Justice Thomas deals with this more in his dissent, so I'll wait until we get there before I dig in. Before we get there, though, we need to understand why Congress passed the Civil Rights Act of 1866 and proposed what became the 14th Amendment to the states. In Dred Scott v. Sanford, the court departed from the common law and adopted the view that blood, not soil, determined citizenship. It held that those descended from slaves could not be citizens. The decision was met with shock. Specifically, the Supreme Court in the Dred Scott v. Sanford case stated, when the Constitution was adopted, they were not regarding any of the states as members of the community which constituted the state and were not numbered among its people or citizens. Consequently, the special rights and immunities guaranteed to citizens do not apply to them, and not being citizens within the meaning of the Constitution, they are not entitled to sue in that character in a court of the United States, and the Circuit Court has not jurisdiction in such a suit. Because slaves were not treated as people, SCOTUS said they were not citizens and therefore not guaranteed the rights and immunities of such. No wonder the decision was such a shock. But once again, we see SCOTUS rewriting history for their own benefit. The 14th Amendment Citizenship Clause mirrored the common law's criteria for citizenship, starting with territory, a child must be born in the United States, and ending with a sovereign power, a child must be subject to the jurisdiction of the United States. Except the 14th Amendment does not mirror the common law criteria for citizenship. It adds a very important condition, and subject to the jurisdiction thereof. But what does that mean? A child born on American soil and subject to the American law was made an American citizen. The Citizenship Clause's key phrase, subject to the jurisdiction, refers to the power of the United States to govern those within its territory. Again, the 14th Amendment does not say, and subject to the laws of the United States. Everyone within the territory of any country is subject to their laws. As Senator Howard stated on the floor of the Senate, this amendment, which I have offered, is simply declaratory of what I regard as the law of the land already, that every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural law and national law a citizen of the United States. This will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of person. The plain intent of Congress, specifically the man who proposed the language and subject to the jurisdiction thereof, was that foreigners and aliens, along with families of foreign ministers, would not be included as citizens of the United States, which leads us to a previous SCOTUS case about birthright citizenship. The court's precedent in United States versus Wong Kim Ark confirms this rule, except the court's precedent blatantly violated the language of the citizenship clause. A child born in the United States of parents of Chinese descent who, at the time of his birth, are subject of the Emperor of China, but have a permanent domicile and residence in the United States and are there carrying on business and not employed in any diplomatic or official capacity under the Emperor of China, becomes at the time of his birth a citizen of the United States by virtue of the first clause of the 14th Amendment of the Constitution. Now, how can a child of parents who, at the time of his birth, were subjects of the Emperor of China be subject to the United States? Yes, they had permanent residency status, but that also points to John Roberts' mistake. In Wong Kim Ark, the court held that the 14th Amendment was declaratory of the fundamental rule of citizenship by birth that prevailed at common law. See, U.S. v. Ark did not confirm the English common law standard. Rather, it conflated legal residency with subject to the jurisdiction thereof.